After proxy in, let's take the roll. Okay, we'll do Surville then, okay. All right, good enough. First up is going to be 1385, Senator Surville.
Thank you, Mr. Chairman. I have a substitute.
All right. Let's move the substitute and get it in front of us. Moved and seconded. We got the substitute in front of us. What's the wonderful bill do?
Thank you, Mr. Chairman. I haven't been given my substitutes. I'm hoping I can pull it up here. But basically what this bill does, it tweaks a bill that we passed in 2019 having to do with a tax that can only be, or a fee that can only be enacted in Fairfax County and nowhere else to pay for underground utility lines in the Route 1 corridor. The amendments that the county requested broaden the county's authority to spend it on projects beyond just the US 1 corridor, but in other places. It also, the substitute, which I still haven't been able to pull up,
I can't get it in.
also places a cap on the commercial tax, the commercial meter tax. The tax could be $1 a month per meter on residential customers, and there was no cap on commercial meters. And so the substitute puts a cap on both the commercial meters and the residential meters. I think it's up to $15 a year, like $1.20 a month, something like that.
You're from Northern Virginia and you're putting a cap on a fee?
Yes, sir, I am. I might get primaried for it, but yeah, I am. And I still can't pull the substitute up, Mr. Chairman. Otherwise, I could help to explain some of the additional changes. But
Mr. Chair, the substitute is on its way. LIS has been having just a little bit of a delay from when we send it to when it actually gets up online.
Okay.
Yeah, I still can't pull it. The one little line amendment I need to make, but otherwise, Mr. Chairman, I know all the utilities, I believe, are fine with the bill, and the county is mostly fine with it. Not entirely fine, but mostly fine.
Okay.
And if I could pull up the substitute, I could make a line amendment, but I can't see it.
That's still not there.
But that's basically what it does, and I'm not aware of there really any real opposition to the bill.
Okay.
But you got to see it before you can vote on it.
Well, sometimes that's helpful. I'm trying to get on it now. It looks like it might be. Well, now I'm not getting anything. Yeah, that would be helpful. Are there any questions for the patron? Senator Favola.
Thank you, Mr. Chairman. To the patron, Senator Servo, on line 45, at least the one in front of me, says no agreement shall require any telecommunications provider or cable provider to share a conduit. I wonder why you put that in, because sometimes sharing a conduit could be a good thing.
Yeah, I don't think the utilities see it that way.
Right.
The idea behind this is they're going to build a duct bank, and the duct bank will have different conduits in the duct bank, one for electric, one for cable, and one for telecom. And as soon as you put two wires in the same conduit, I think it gets harder to maintain and repair it, and so they want separate conduits. And I think that was something that was requested specifically by Verizon, I believe.
Follow-up question, Mr. Chairman.
Senator Favola.
Chairman, the substitute's up now.
Is the county, so the county would never have, would probably not expect to ever ask them to share the conduit, and they're okay with this exclusion? They're okay with
Sorry,
this
can you say that again?
The Fairfax County is okay with this language about no agreement shall require?
Mr. Chairman, yes. The two changes the county would like made to this, which I don't think is a good idea, is number one, they want the State Corporation Commission to review any kind of contract and approve it. and the SEC doesn't get involved in this. This has nothing to do with ratepayer reimbursement, and the SEC is pretty busy, and they didn't want to be involved in reviewing the cost of this. When it's been done in other localities, the SEC's had zero involvement, and I didn't feel like bringing the SEC's opposition into this discussion. And secondly, the county has also requested that the changes contained in this bill be contingent on us appropriating money, Madam Finance Chairman, to pay for this, for the project. Delegate Krizek has proposed a $40 million budget amendment for state taxpayers to underwrite part of this project. And it's the custom of the House not to include finance clauses on their bills. And I don't think this needs a finance clause. The money discussion to me is a separate discussion from these changes. And so that's why I did not include those two changes. Mr. Chairman?
Yep, Senator Servo.
The line amendment I would ask somebody to move is on line 14. I would like to add the word written between and in agreement, just so it's clear that the agreement has to be a written agreement. That was requested by Verizon.
All right. Is there a motion on
So
the line?
moved.
Moved and seconded, we adopt the line amendment. All in favor, say aye.
Aye.
Aye. Substitutes amended. Any other questions for Senator Surville on 1385?
Mr. Chairman.
Senator Bell.
Yeah, just a quick question on the initial amount, which doing the math is $1, basically the 6.67%. Once the bus rapid transit, the initial proceeds go there, what happens after bus rapid transit's funded?
So, Mr. Chairman, the bus rapid transit project, this is a $900 million transportation improvement. It's part road widening, part 8-mile-long bus rapid transit. There's been about $500 million appropriated so far. There's about 200 to 300 million still that's going to come from the federal government. The project's going to take 7 to 9 years to construct, but the utilities have to start going in about 5 years. And so what this bill does, it authorizes the county to start the tax, to start collecting that money over a period of time. It'll take probably about 16 years to pay back the money that's going to have to be fronted. This tax, in theory, could be bonded off by the county, so they could dedicate the tax proceeds to a bond to get the money up front, et cetera. But part of the amendments that the county requested to this would allow them to dedicate these monies to other projects besides the Route 1 project at any point in the future. So they could apply this to 10 projects over 50 years. It's not only limited to this one project. All the bill says right now is that they have to prioritize the Route 1 project, but they can spend it on other projects after that. Does that answer your question?
Mr. Chairman, basically it never goes away.
Correct.
Mr. Chairman, follow-up question?
Scott, can you take your mask down so we can?
Yeah.
Thanks.
It says anticipated extension of Metro Rail. What happens if that doesn't happen?
That language was just put in to describe the project that had to be prioritized. It's not contingent on that project being built. It's just, I needed to come up with language that described which project was going to be prioritized, and the comprehensive plan projects that the metro will be extended down that road along with the bus rapid transit, which is currently being designed and funded.
Thank you, Mr. Chairman.
All right, Mr. Chairman, I move that we report to, does this have to go to finance?
No.
It shouldn't have to. Okay, I move that we report the substitute as amended.
Mr. Chairman, just making sure there's no public comment.
I have one, Mr. Chair. Rick Cornwell, please go ahead.
Can you hear me now?
Yep.
Okay, maybe you might be able to see me now also. We appreciate the work that Senator Surville has put into this bill. I'm Rick Cornwell with Verizon. In addition to his helpful amendment this morning to specify written agreements, throughout the bill, I can't see the substitute, but I'm familiar with the language. And throughout the bill, it refers to lines for providers. We'd like to see that word changed to facilities. that encompasses everything that goes underground.
Mr. Chairman, I got no problem with that technical amendment.
Second? Aye. Aye.
Thank you.
All right. Any other public comment? I'm sorry.
We have one more, Mr. Chair.
One more.
Tim McCormick, please go ahead.
Hey, good morning, Mr. Chair and members of the committee. Tim McCormick on behalf of the Virginia Cable Telecommunications Association. I just want to say that we support the bill as amended.
Great. That it?
All right, I made a motion, Mr. Chairman.
It's
You
been
need a
am-
second.
Well, it's been amended again, so maybe you better make the motion again.
Okay, I move the substitute with both amendments.
Moved and seconded that the substitute as amended be reported. All in favor?
Ayes 13, no 0, one abstention.
Thank you, Mr. Chair.
Yes, sir. All right, let's go back over and we'll take them in the order that they, and if Senator Deeds, whenever he gets free, he's got a very easy one, and they've got a hellacious docket over there in court, so I told him to pop in whenever he gets a chance, and we'll take him. But other than that, we'll go in the order of the docket, and that would be Delegate Wright's House Bill 1743.
Thank you, Mr. Chairman. House Bill 1743 relates to industrial development authorities, and what it does is reduces from 7 to 5 the number of members that may be appointed to the Industrial Development Authority boards by the towns of Cambridge and Victoria, and reduces the quorum requirement to 3 members. And Mr. Chairman, ladies and gentlemen, this bill was brought to me by both towns, and they're small localities. They have a hard time getting members to serve on different boards and organizations. There's no pay involved and so forth. So it is a difficult task. And so I would ask about the body to pass this bill, and I'll be glad to answer any questions.
Any questions for Delegate Wright on House Bill 1743? Do we have any public comment on 1743?
If you would like to speak in support of the bill, please raise your hand.
Nobody? Okay. Yeah, let me just point out to the committee, this passed through the House Committee 20-0 and the floor 99-0. So
Motion has been made.
moved and seconded that we report 1743. All in favor? All right, Delegate Wright, there you go.
Ayes 13, no 0.
Thanks, sir.
Thank you. Thank you.
Delegate Walker, we have 1768.
Thank you, Mr. Chairman. House Bill 1768 is legislation that comes from the city of Lynchburg for the General Assembly to consider revising the Articles of Incorporation of the Lynchburg Parking Authority to amend the terms of the authority members from 5 years to 3 years. The city has experienced difficulty in finding individuals to serve on this board, and one that was cited was reasons that it is longer than normal terms for other boards and commissions. So the city requests this bill be put before you. Thank you, Mr. Chairman.
Thank you, Delegate Walker. Any questions for Delegate Walker on 1768? No questions? This one came out of County, Cities, and Towns 20-0 and 99-0. Yeah, any public comment?
Mr. Chair, if you would like to speak to the bill, please raise your hand.
It's too fresh, Senator Stanley. No. All right, is there a motion on the bill? Moved and seconded that 1768 be reported. All in favor?
Ayes 14, no 0.
All right, Delegate Walker.
Thank you, Mr. Chairman.
Delegate Askew, 1825.
Good morning, Mr. Chair, members of the committee. Today I have before you HB 1825, which makes small technical amendments and changes to provisions related to bond issuance to the purposes for Virginia Beach's sports and entertainment complex project. It was commonly referred to as the Dome site. It's concerning issuing and refunding bonds. I hope it'd be the pleasure to pass this bill along, Mr. Chair.
All right, are there any questions of Delegate Askew on 1825?
Move the report, Mr. Chairman.
Wait a minute, whoa. Let's see. We got any public comment on 1825?
If you would like to speak to the bill, please raise your hand.
And I assume, Delegate Askew, this is coming at the behest of Virginia Beach, correct?
Yes, sir, Mr. Chair. And I believe there's a somebody from the city on the line if necessary.
Doesn't look like it's necessary. All right, we've got a motion and a second on House Bill 1825. And as far as we know, we've gotten no requests from finance on 1825. So
That is correct, Mr. Chair. Ayes 14, no 0.
all right, I'm going to direct the committee's attention to Senator Deeds.
Senate Bill 1267.
1267.
Yes. And basically, it waited this long because we had to have the public hearing in the city of Covington. It's a charter change for the city of Covington, basically, that will allow the city to consolidate their school system with Allegheny County. Both these localities have gone through an awful long process, a public process where they've agreed to do this. It's been approved by the State Board of Education. All of that's occurred. The State Board of Education and City Council occurred just last week, so those approvals.
Great. Could there possibly be any questions on 1267? Okay, any public comment on 1267?
If you would like to speak to this bill, please use the Zoom raise your hand feature.
Is there a motion on 1267? Moved and seconded that 1267 be reported. All in favor? Thank you, Senator Deeds.
Thank you very much.
Ayes 15, no 0.
Next up, we have House Bill 1859, Delegate Guy.
Thank you, Mr. Chairman, members of the committee. House Bill 1859 makes two small changes to the CPACE legislation, CPACE being the Commercial Project Assessed Clean Energy Program that was created by the General Assembly 4 years ago that allows, matches up private investors with commercial projects that qualifying commercial projects and allows the loans to be paid back through an assessment program administered through localities. The two changes are one, to clarify that residential rental real estate projects are included, but residential owner occupied projects like condominiums are not. And the second is to allow a reach back provision for projects that have been completed within 2 years of enrollment that otherwise qualify and that they can find matching resources for to be enrolled in the program. I have both John Warren and Michael Skiffington from the Office of Mine, Minerals, and Energy here to answer any questions, and I believe Abby Johnson is here as an advocate. I hope it'll be the pleasure of the group to report the bill on. Thank you.
All right, are there any questions for Delegate Guy on 1825? I'm sorry, wrong bill, not 1825. 1859.
Yes, sir.
Well, wait, let's see. Let's hear from, I think we may have some folks interested in this.
Yes, Mr. Chair. Abigail Johnson, please go ahead.
Thanks, members of the Senate committee. This is my name is Abigail Johnson. I'm the program administrator for the Virginia PACE Authority, which manages programs for CPACE in the state. And I just am here to support these changes. It'll allow more businesses who have suffered from the impacts of the weak economy to take advantage of this loan product. It is really focused on helping buildings and property owners with businesses in them be able to finance energy efficient, renewable energy, and now resiliency measures. So it's really going to help our small businesses and large businesses alike. So I'm here to support Delegate Guy in her effort here.
Thank you. Next.
Michael Skiffington, please go ahead.
Good morning, Mr. Chair, members of the committee. Michael Skiffington with the Department of Mines, Minerals, and Energy. We strongly support the bill and appreciate Delegate Guy's work.
Next up. Thank you.
And our final speaker, John Warren, please go ahead.
I am the agency head for DMME and agree with Mike, the department and the governor's office support this bill.
Okay, thank you. Anybody else? All right, that's it for public comment, and there are apparently no questions for Delegate Guy. Is there a motion? Moved and seconded that we report 1859. All in favor? All right. Thank you, Delegate Guy.
Ayes 11, noes 2, 2 abstentions.
Next up is House Bill 1927. Delegate Sickles.
Thank you, Mr. Chairman, members of the committee. This bill, the Fairfax County is seeking to add 2 members to its Economic Development Authority. 50 years ago, it was created. It's had 7 board members since that time. Our economy has become much more complicated. It's a global organization with offices around the world, and it just wants to more effectively represent all the business types and organizations in Fairfax County. Just as a little bit of brag, we have 11 Fortune 500 companies in Fairfax County and 113 of the fastest growing companies in America. And they just would like to increase their number by two, and the quorum requirement would grow up by 1 from 4 to 5. That's what the bill does. Thanks, Mr. Chairman.
Yep. Thanks, Delegate Sickles. Any questions for Delegate Sickles? Is there any public comment on 1927? All right, let's hear from him.
Chris Sigler, please go ahead.
Thank you. Good morning, Mr. Chairman, members of the committee. Chris Sigler representing Fairfax County. Delegate Sickles accurately described what this bill does and why we need it. The enabling authority for our EDA came to us in 1964, and since that time we have an increased membership on our board. The business community in Fairfax is totally different now than it was in 1964. So adding these 2 members is going to enable us to further diversify the business perspectives on this board, and we think it's a good thing ultimately for Fairfax County. So we hope you will report the bill. Thank you.
Thank you. Anybody else? No more public comment on 1927. If there are no other questions for Delegate Sickles, is there a motion? Moved and seconded that we report House Bill 1927. All in favor?
Ayes 15, noes 0.
Thank you, Mr. Chairman, members of the committee.
Thank you. Next, we have up House Bill 1949, Delegate Runyon.
Mr. Chairman?
Yes.
The Delegate Runyon had a conflict. I believe this bill is identical to Senator Reed's bill.
Mr. Chairman, this is the same bill I had that came out of committee. It's a bill that will allow 2 localities, one of which I represent, Albemarle County, that have an executive form of government, to allow them to retain the proceeds without having to go through the finger drill of reappropriating and everything else on capital improvement projects from one year to another.
Okay. Senator Reeves, is it really identical to your bill?
As near as I can tell in my cursory view of it, I think it's pretty close, and if it's not, we can fix that between the 2 bodies.
All right.
Maybe council can do a double take on it.
Okay. All right, it's been moved.
Mr. Chair, the bills are identical. The 2 bills are.
Thanks, Jeff. Okay, they are identical, Jeff says. Been moved and seconded that House Bill 1949 be reported. All in favor?
Ayes 15, noes 0.
Okay. Next up, well, we'll give you controversy now. Next up is Senator Hanger, the star of the show, Senate Bill 1355.
Y'all heard about this one? Thank you, Mr. Chairman, members of the committee. As you all would be aware, this deals with a service authority. Greene, Orange, and Madison counties are all members of this service authority. We passed this bill to the floor, and it appeared that we could make it better, and so I asked that it be returned to committee, and I do have a substitute, Mr. Chairman, to offer, and then I have an amendment to the substitute. And you want me to explain what I'm doing before we adopt them, or?
Let's just get it in front of us.
Mr. Chairman?
Is it on the system?
Mr. Chairman?
Yep, Senator Reeves.
If he could explain those, because I represent one of those districts and I've got 3 separate letters and miscommunication. If he could do that, that would help clarify it for me.
I'd be glad to do that. First, the substitute itself, which I guess we probably will need at some point to back off of the original substitute the committee offered and adopt this substitute. Okay, all right, that's what we'll do. Mr. Chairman, essentially we're talking about a disagreement between neighbors, and I represent both of those neighbors. Last week, as a part of the process, a negotiation began, which that's really where we wanted to get to, a negotiation rather than this going to court. And so the 3 members have talked, the 3 counties. Orange County, which Senator Reeves represents, offered amendment which is embodied in the substitute. And if we adopt the substitute, they've already signed off on a letter to say that they do support the bill. All right, it was thought when this was offered that Madison County might also support the bill. They met yesterday in emergency session, and at that point decided that they didn't want to sign on to the letter. So I want to make that clear. They didn't sign on to the letter, but Orange County and Greene County did, and the intent is to continue the negotiations. So that's what the substitute does. The substitute essentially clarifies the disposition of assets if one member withdraws, in terms of how that would be handled, because that was not addressed specifically in the original bill. So that's contained in paragraph 3. So if we adopt the substitute, I would propose to adopt an amendment to that, which I think should, and I can't speak for other parties, but it should level the playing field so that this bill could move forward and negotiations could continue. And I will read this just to be clear, Mr. Chairman. The amendment that I'm going to propose to the substitute basically takes the prejudice out of it in terms of whether a member withdraw or not withdraw, to level the playing field, if you will. And it would say at the end of this bill, say, prior to withdrawing, a member of the Rapidan Service Authority shall first enter into, now the way I had Legislative Services draft this, it says mediation, and I'm going to offer an amendment to say everywhere there says mediation that we will say negotiation. So I want to read it that way. Prior to withdrawing, a member of the Rapidan Service Authority shall first enter into negotiation to discuss and attempt to resolve issues of difference. Such negotiation shall include representatives from all member localities and their legal representation, representatives of bondholders, a facilitator, and any others as may be appropriate for technical assistance. Primary consideration shall be given to the potential adverse impact to all parties if a member withdraws, and potential adverse impacts to all parties if a member is prohibited from withdrawal. Any tentative negotiation agreement shall also require the agreement of all bondholders. So that is the substitute explained and the amendment that I would propose to make to the substitute, Mr. Chairman.
Second.
All right, it's been moved and seconded that we adopt, I guess, first the substitute offered by Senator Hanger. All in favor? Aye. Aye. Opposed? Okay, the substitute's in front of us. Now, I'm sorry, Senator Spruill?
Senator, what happens if one member withdraws? What happens if one member just, when you try to work it out, and one member said no?
One member withdrawals?
Yes, sir.
Okay. Mr. Chairman, I would say to Senator Spruill that they would be prohibited from withdrawing without the concurrence of all bondholders. And that really is the point that I would stress, that protects all parties, and that bondholders would not sign off on an agreement that would adversely impact any debts owed by remaining members, or if the withdrawing member was not capable or in position to service a debt as a single entity rather than a member of the authority.
Thank you.
All right, moved and seconded that we adopt the line amendment or the amendment to the substitute. All in favor? Aye. Aye. Opposed? Okay, so we've got the substitute as amended in front of us. And Senator DeSteph, I see you in queue. Do you have a question?
Yes, sir. I just wanted to know if there were still 2 lawsuits pending on this.
Mr. Chairman, I would say the negotiations that have already begun would negate the necessity for these lawsuits, and I think those lawsuits would obviously be dropped if the parties were able to come to a negotiated agreement.
Senator Donovan.
Thank you, Mr. Chairman. And Senator Hanger, why negotiation and not mediation? Why is there that language change?
Madam Chair, I guess lawyers may have a different interpretation of the difference between negotiation and mediation. I think mediation, in my mind, indicates that there is maybe more of a problem that's an outsider had to come in to resolve it for them. And essentially, we are proposing a facilitator, but perhaps there's not really a distinction other than it was thought that it would be more agreeable to all parties if we substituted the word negotiation rather than mediation.
Senator Donovan, anything else?
Just to follow up,
sure.
Mr. Chairman, we all want, when it's an alien, set of counties for us, before we use the sledgehammer of the legislature, we just want to make sure that we're not picking winners and losers without understanding the whole situation. And I'm just getting some feedback that mediation is a more desirable amendment to have, because I think that because of an outsider, there's the opportunity for, kind of everybody to have a counselor, if you will, not in the context of, a lawyer, but, more in a psychiatric means. So
right.
I think maybe we'll listen to public testimony and maybe circle back around. I think that nuance may matter. I don't know.
Do you propose an amendment, or you just want to see this play out, Senator Donovan?
Not at this time, Mr. Chairman.
All right. Senator Stanley.
Mr. Chairman, thank you. Mr. Chairman, I'd ask the gentleman, as long as I've been here, and I've crossed over the Rubicon there on a number of occasions, that when we have pending lawsuits and outstanding issues that are before the court or even in mediation, we don't legislate them away. Can you assure me that what you're doing here isn't legislating away having a court of competent jurisdiction determine this lawsuit, or a mediation to give an attempt to settle this lawsuit? And my understanding there are 2 lawsuits against the authority, and then there's a separate lawsuit that challenges even the legality of the facility fee tax itself. So that's 3 lawsuits that we're now waiting as a legislature and making a policy decision we're wading into. Can you tell me, is that your intent, or this is around all of that?
No, Mr. Chairman, I would say to Senator Stanley that there's a difference, because we're not legislating policy, we're not legislating an outcome. We're basically facilitating a negotiation or a mediation, if you want to call it that, so that it wouldn't have to go to court. Obviously, we stay away from issues of policy where if we intervene and change the rules of engagement, that's different than actually facilitating a negotiation, mediation, as we're proposing to do here.
Mr. Chairman.
Senator Stanley.
Mr. Chairman.
And you would agree there's a mediation. I guess the parties have agreed to mediate at this time as a part of that litigation?
The parties, yes, the parties are agreeing to a negotiation, mediation, whatever you want to call it. We have that, just as of last week, with the incentive of this bill, the parties actually have come together and started discussing how this could be resolved.
Mr. Chairman.
Senator Stanley.
And so, being a trial lawyer that I am, and I have enormous respect for you, Senator, if your bill, merely by its filing, have gotten the parties to talk, that's a good thing. Why do we need to follow through with it, with the unknown being whether they're going to resolve their issues or not? Because in litigation, we always have the opportunity to mediate if the parties agree, and it seems like you've got that. And the negotiation, which happens right up to the courthouse door at the day of trial. Why don't we let the process work itself out? Why do we need to inject ourselves here in a manner that seems to me ultimately counterproductive? It's like the General Assembly's holding a spear at their backs and saying, you do this or I'll do it for you. Like my dad used to lovingly say to me when I was a kid, when I want your opinion, I'll give it to you.
I understand that.
Okay. Mr. Chairman, I would say to Senator Stanley that as a non-lawyer, I prefer to resolve issues outside of court rather than pushing them into court. It's if you have the experts at the table and willing parties that essentially are friends but have a disagreement that could be worked out. The reason why I want to continue the bill right now is because the same incentive as the bill was there that caused the conversation to start will be there to provide that incentive for them and opportunity. And it's not a sword or a knife at anybody's back because it doesn't propose an outcome at all. It just facilitates a process short of having to go to court.
Mr. Chairman, I thank the gentleman.
Chairman?
Senator Favola?
Oh, Senator Stanley, are you finished? I'll
Yeah.
yield. I can go? Okay, thank you, Mr. Chairman. My understanding, and please correct me if I'm wrong, is this mediation would sort of negotiate if you will, negotiate the details of what would happen if a jurisdiction left. In other words, what financial obligations would still be incurred by the locality, and so no matter what happens with the court cases, there's still going to have to be sort of a negotiation to keep the authority whole and to allow the jurisdiction to exit.
Mr. Chairman, I would say to the Senator that yes, this actually negotiation would proceed and basically negate the need for court action in terms of getting into the details. And the backstop, as I've mentioned before, is that the bondholders are at the table, in addition to a facilitator and the parties that have the disagreement, so that the interests of all parties should be protected in terms of financial ability to continue to serve their citizens in an appropriate way.
Before we go to public comment, are there any other questions for
Mr. Chairman, Senator
Reeves?
Mr. Chairman, the best way I can describe this is it's a marriage of three counties, and we're going through divorce court right now, and this is a post-nuptial agreement after the fact. And I feel for Senator Hager because he and I both represent these districts, and I'd rather not be here. But I don't know that it's right that we do a post-nuptial on these folks. They knew what they were getting into when they first got in it, and I have to refer to unfortunately, my seatmate, who's of keen legal prowess, that I don't think we can change the terms on them when they're in the middle of the fight. So I'm going to be throwing up a no.
All right, Senator Reeves, let's listen to the public comment. Ready?
Greg Habib, please go ahead.
Greg?
Mr. Chairman, members of the committee, can you all hear me okay?
Yeah, we've got you.
So I apologize. The first time this bill came up, I told you it would be fairly simple, and it was that time. This is why I don't do local government work in my legal practice, because these things get complicated. Let me actually jump to Senator Stanley and Senator Reeves' comments first, because I think they're actually the fundamental issue that has not been said, and why I hope any potential no votes reconsider. The reality is the parties cannot mediate without this bill because of the existing law. So yes, there is litigation, but they cannot mediate. There is not a resolution without this bill. And the reason for that is the existing code says you cannot depart an authority unless the bonds are all paid off. You cannot resolve this because there are existing bonds. What this bill says is it eliminates that barrier to mediation, but protects the bondholders by mandating they be part of the process. And so for years, I, as a member of the General Assembly, killed bills that affected litigation. This is actually the opposite of that. If you want these parties to resolve this, we have to pass this bill. It is literally legally impossible to mediate any pending actions if this bill does not go forward. And so I appreciate your sensitivity to that issue, but this is different. The code says,
Mr. Chairman, can former Delegate Habib tell me what that code section was again so I can refer back to it?
sure, it's the code section that the bill is, that 15.2, 5014, the general authority legislation that says there's two prerequisites to departing an authority. There's two of them. One of them is all authority members must agree, and two, all debt must be paid off. And the problem here is there's lots of debt, and it's appropriate debt. And the whole point of the mediation is to allocate who's responsible for what. And Senator Hanger's bill very thoughtfully forces the bondholders' approval. And so while what the General Assembly has said is it's a policy decision that an authority member shouldn't leave if that exposes bondholders to risk because of existing debt. What this says is you can still leave if there's debt as long as the bondholder says it's okay. And so if you want these parties to resolve this, you have to put this bill forward. If we don't, the only solution is really nasty, really expensive litigation to deal with a whole bunch of ancillary issues that still may not resolve the issues between these parties unless a court lets Greene County or Orange or whoever leave. And so what we need, what you all have done by keeping this bill alive is not just spurred the conversation, it's provided the legal path to potentially negotiate a resolution. And Orange and Greene, who make up 95% or so of the Rapid Hand Service Authority, have asked for this bill. They are supportive of this bill. They've provided a joint statement signed off advocating this bill. And Madison, while it has not endorsed the bill, has endorsed mediation. And again, you can't mediate without the bill. Senator Donovan, to your question about mediation versus negotiation, it's actually a little bit semantics to the localities. They don't want to be forced to waste a bunch of money and be treated like children who can't resolve it if they can just work it out between the three of them. That's why they ask for negotiation versus mediation. But Senator Hanger's language still requires a facilitator, which for those of us who mediate for a living, that's really the same thing. So whether if you pick either word, I don't think that really matters. Senator DeSteff, just to answer your question from a technical standpoint, there were two separate lawsuits filed. One was about a facility fee and monetary damages. The other one was about the RSA illegally excluding Greene from participation. That's not about departing the RSA. Those lawsuits have been consolidated into one claim.
Code section. Read it.
Wait a minute. What happened? We've lost you, Greg.
Sorry, I heard someone talking. I wasn't sure what was happening there.
Go ahead. Go ahead.
Did Senator Reeves have a question about the code?
No, not yet.
Mr. Chairman, if Mr. Habib, I'm looking at the code section, I'm reading it. It doesn't say it prevents them from not being able to mediate. It says, I'll just read it. The governing body of each participating locality shall cause to be advertised at least one time in a newspaper of general circulation, such locality, a copy of the ordinance, agreement, or resolution creating an authority, or a descriptive summary of the ordinance, agreement, or resolution in reference to the place where the locality where a copy of the ordinance, agreement, or resolution can be obtained, and notice of the day not less than 30 days after publication of the advertisement on which the public hearing will be held on the ordinance, agreement, or resolution. It says nothing in that code section about the inability to mediate.
So, and I don't have the code section right in front of me. My point, it doesn't say anything about mediation. What it says is about withdrawal of a member. There's a section that talks about when a member can withdraw, and that section limits withdrawal to unanimity amongst the members and all debt has to be paid off. This is the same thing that you all did with SIPSA years ago, and gave approval to withdraw even though the bonds. So it's 15.2, 5112, 5112. no locality may withdraw from any authority that has outstanding bonds without the unanimous consent of the holders of the bonds. And then it goes below there, you have to have the parties signed off. That's all this is trying to do, is facilitate the opportunity to mediate a departure without those barriers. That's all it is.
But Greg.
Mr. Chairman.
One minute. Greg, this, in my mind, this still would not preclude, on a practical level, mediation between the parties. I mean, if it didn't go forward.
I think there are barriers to a successful resolution of that mediation that will cause the parties to simply litigate instead of mediate. And we might as well keep that opportunity open so these counties and this authority don't waste a bunch of money that they don't have fighting over a marriage. Senator Reeves's analogy is the right one, but it's not a postnuptial, it's the equitable distribution in a divorce. So postnuptial is different. This is absolutely unequivocally a three-party marriage that should be dissolved on some level. They should be given the opportunity to seek a divorce, and you should equitably distribute the assets while protecting the creditors. And that's what the bill attempted to do.
Senator Reeves, do you have a question?
Mr. Chairman, I think I found it in 112 code section, or 511, 5112 code section. I answered my own question.
Oh, okay, all right. Any other questions for Mr. Habib or Senator Hanger? All right, next speaker.
Rob Shin, please go ahead.
Good morning, Mr. Chairman, members of the committee. Pleasure to be with you today. I think some of the key points have already been made by committee members, but I think the most important one is there are two pending lawsuits, as Senator Stanley said, filed in September 14th, September 28th. And it is the longstanding tradition of this body not to pass legislation with pending litigation happening. Regarding the mediation negotiating question, I think when I first talked with Senator Hanger about the bill a little more than a week ago, his feeling was that the bill was not necessary, that mediation was the solution, and in his point of view, the legislation would help promote mediation. We've accomplished that. Mark Rubin has been discussed with all the parties as the appropriate mediator. You can call it mediator, negotiator, but without question, the way this is going to be solved is getting the parties together and sorting it out themselves, and not do it through the legislative process. The fact is, the Virginia Water Act, which this is trying to, the legislation is trying to supersede, is there to protect all members of the authority, including the most vulnerable, which in this case is Madison. If Green is allowed out without an equitable distribution of assets and situation, it's Madison that's going to be hurt the most in this process. And that's why mediation has to take place. If you look at lines 21 and 22 in the substitute, what this says is that the assets remain with the locality where they're owned. That doesn't even get into the issue of joint assets. I was on the phone last night with Jim Crozier, the Orange County chairman of the Board of Supervisors, and he took exception with that language because things like the maintenance shop, the administrative office, the repair shop, they're located in Green, but serve all the counties. Now, I think Orange is of the opinion that Green should be let out, but I think he thinks mediation is really the way to go because you need to sort out all these things in a very thoughtful way and not legislate it. Lastly, I'll say you can't unwind the contractual agreements between the parties. And in fact, in the legislation, it talks about line 18 that all written obligations to the authority shall be in full force and effect. Well, that's really what the dispute's about. Yes, there are bond issues, but there are written agreements of the parties. And Article 1, Section 11 of the Constitution says you can't, by legislation, abrogate contracts and agreements. When this came up under the Southeastern Service Authority back in 2006, a very similar issue, Judge Forehand for the Circuit Court essentially said the parties couldn't abrogate their contracts and agreements through legislation, affirming that. So as much as, you know, we'd like to think legislation could solve this, the way forward is not pass the bill. The parties have agreed to mediate or negotiate, whatever you want to call it. That's the way this needs to happen. The divorce or whatever you want to call it, or however it ends up, all the parties are motivated to fix this. And I would submit that letting Mark Rubin work his magic in mediation negotiation is how we can get this solved.
Any questions for Mr. Shin? Any questions for Senator Hanger in light of Mr. Shin's testimony? Okay.
Mr. Chairman.
Senator McPike.
Just a question for the patron. Mr. Shin brings up sort of an interesting point, which is if the language sort of reads a predisposition of ownership in terms of where the facility exists, how would you respond to that? Because that does take a proactive policy position within the bill versus the other sections seem to be hands-off and letting party. But this sort of line does sort of predictate an outcome. Can you speak to that?
Yes, I can. And actually, as I was following Rob and his comments there, it appeared that his comments by the Lindsay reference were speaking to the original bill that went out to the floor rather than the substitute that we just adopted. And that was Orange County's point. Orange County, in a similar situation to Madison, and originally not supportive of this bill, drafted language with their attorney to correct that. So in the substitute, we actually have a more thoughtful response to the distribution of assets rather than the sections that Rob was referring to. So that is addressed here in a thoughtful way. And there's the disparity that exists is in part because of the growth in Greene County versus Madison and Orange. And Madison, I want to protect their interests. I want to be clear about that because I represent them as well. I talked to the chairman of the Board of Supervisors just this morning. Greene County now has 3,000 members, subscribers in the Service Authority. Madison has 175. It's just a whole different thing. Greene, as most of you who would be aware of the area north of Charlottesville, is growing rapidly and has already lost potential economic development, significant potential economic development, because of the fact they have not been able to address the needs of water and sewer for people who wanted to move there, for businesses that wanted to locate there. So this does not change policy. It does not state where this is going to end up. It merely allows the opportunity. And as the proponent counsel there, and it wasn't one of my big points, I wanted to make sure they negotiated or mediated this as neighbors that had a disagreement. But the point that was raised about not being able to withdraw without legislation, and in fact, in spite of what the court might have had to say, there was litigation involved back with down in the Chesapeake area at that time as well. The bill passed, and they were able to withdraw because that met the interests at that time of all parties. So this is what this merely does, just replicate what we did way back, I think it was 2002, 2006, somewhere along that way. So that has been anticipated, Mr. Chairman.
Senator Donovan.
Thank you, Mr. Chairman and Senator Donovan. I guess my only question is trying to sort through this and sympathetic very much to that economic development and the other issues you've cited. Just as I look at this as a layperson, it appears to me that it directs mediation except for the decisions the legislation's already made in the mediation. So you have in here some of the things that I can only guess would be negotiated in an open negotiation field, like any written obligation in line 11, which is the one that was alluded to by Mr. Shin, but still in here. It seems like we cite these are the things that will be predetermined before mediation, and then you can mediate the rest. when I'm thinking if I were looking to solve a problem for me, I'd want to have the opportunity to negotiate on every variable and not just the ones that are left over after this. I think that's my concern about the legislation. Coming into this situation predisposed to support it, I have concerns about that, and I don't know if you can address that, but it doesn't sound like it's full mediation. It sounds like it's mediation except for what we legislate.
Mr. Chairman, I can only respond that the language that we substituted this morning was after there had been a round of negotiation amongst the parties, which one of the parties submitted, and that brought them to the table in support of the legislation. And it doesn't get too specific other than just broad parameters, which are common sense elements of an agreement. So I mean, we could take that out, and if you feel that that's where they need flexibility in that as well. The one thing that I would stand firm on, we can't take out the ability of the Virginia Resource Authority, the bondholders, to okay or disapprove any agreement that might be reached.
Mr. Chairman,
Senator Donovan.
could Delegate Habib maybe respond to that question too?
Greg?
Sure, Mr. Chairman, am I unmuted?
Yeah, you're good.
So Senator Donovan hit right on the language that's important for what Mr. Shin said. What happened in Chesapeake was a bill was proposed that let Chesapeake out of its written obligations. And that's why the court said you can't interfere with that existing contract. The reason line 11 in the substitute exists is to not interfere with the contract. So what you heard was a cite to a case that did the opposite of what this bill does. That bill eliminated Chesapeake's obligation to use SIPSA. This bill says, no, Green, if you have written obligations, you still have to meet them, but otherwise they can have the opportunity to withdraw. That's what makes it constitutional. And Senator Donovan, that's why we have to limit that language, that part of the mediation. And then the other point that was just made was about assets that Mr. Shin made, was about assets in green, but that was only reading half of the bill. And so the first part of the bill says assets within the jurisdiction go with the jurisdiction. But in Senator Hanger's amended language, it says joint assets will be negotiated. And so that's the whole point of this. It actually is on line 29. It says any shared assets used for the maintenance and operation of the combined utility system shall be proportionally distributed to the member jurisdictions as applicable. So the issues that were raised have been addressed by the substitute.
Raise your hand if you want to talk again.
Senator Donovan, do you have a follow-up? Okay. And let me, I don't think we at the outset asked, Mr. Habib, who do you represent?
All right, I represent Greene County. I have a joint statement signed by Greene and Orange in support of this legislation. I think I see Sean Gregg on here who might be looking to testify. I think he's counsel for Madison. I don't think anybody from Greene is on here, but they might be.
All right, and Mr. Shin, who do you represent?
I represent the Rapidan Service Authority.
Just to be clear, okay. Is Sean Gregg on there? Sean Gregg, long time no see. You there?
Good to hear your voice, Mr. Lewis.
Yes. Sean has an excellent undergraduate education. Go ahead, Sean.
It's only as good as Mr. Lewis's. In any event, I certainly, and I do represent Madison County, and I certainly appreciate the opportunity to speak on this bill. Madison County has pretty serious misgivings with the bill and would urge you to vote against it. Someone used the term knife in the back. Well, it feels like over the weekend, Madison County woke up with a pretty serious backache. Here are the problems. The way that the current statute, and I believe it is 15.2-5112 is the one that's being amended. It's not 5104 or 5109, which were mentioned. There's really a two-step process. The most important part of the process is the unanimous consent of the three constituent counties in this case. The problem Madison County has with this is Madison County, as has been pointed out by a number of people, Madison County has the fewest users, and in some ways, you might argue, has the least dog in the fight. I would submit that it's actually the opposite. Madison County does not have the economies of scale to run its own sewer system and water system. The real problem, and you may look at the numbers and say, well, it's only 175 to 200 users. Well, one of those users is the Madison County Public School System. One of the suggestions that has been made is that Orange County and Madison County would continue to work together, but there's some difficulty with that from a practical matter. The physical plant that Orange County maintains is located in Lake of the Woods, Virginia, which is about a 55-mile drive from that physical plant to the Madison County facilities that would require work. It's going to be very difficult for them to serve that. My math may be wrong. I was just using the ways that I would go. I've never tried to get from the Madison County Courthouse to the RSA plant in Locust Grove. And the real problem with that is if this bill is passed, there is nothing preventing Orange County from deciding it does not want to serve Madison County in the future either. And that is a huge problem for us. One of the reasons that we strongly discourage the passing of this bill and would urge you all to vote against it is because we believe that the litigation does in fact give us a context to solve this. If you have unanimous consent of the parties through mediation, negotiation, whatever term you want to use for it, that at least gives everybody the opportunity to have some give and take and all the rest of it. If you remove the unanimous consent, you are changing the rules of the game in the middle of the litigation, because currently the law is that it has to be unanimous, and you'd be changing it so that it is no longer unanimous. Madison County is...
Sean,
yes.
hang on a sec. I think Senator Spruill has a question for you.
Yes. What happens, sir, what happens if there's not a unanimous consent among the debaters?
I don't know what would actually happen. I can tell you what Madison County's fear is.
No, I ain't talking about that. I'm talking about, that was my question. If you keep saying about unanimous consent, so what happens when the three get together and there's not a unanimous consent? Then what happens now?
Then the status quo continues to exist.
Thank you, sir.
Yes, sir.
Go ahead, Sean.
Okay, and just finishing on that point, the litigation gives us a means of having that unanimous consent so that we can come up with an equitable arrangement. If we do not have the unanimous consent, then any of the counties can do whatever it wants, and for all intents and purposes, the service authority ceases to exist. Thank you.
All right. Thank you. Any questions for Mr. Gregg?
Yes, sir. One last question.
Sure, Senator Spruill.
Thank you, Mr. Chairman. So if the service authority ceases to exist, then what happens then with all the three counties if they cease to exist because they can't come to unanimous consent? What happens then?
My fear is that what would happen is Greene County would run its system. It has the economies of scale to do so. Orange County would run its system. It has the economies of scale to do so. Madison County does not have the economies of scale to run its system. I don't believe that any facilities belonging to the Rapidan Service Authority are actually located in Madison County. There is a water treatment plant that largely serves the town of Madison, but in terms of the physical plant, the maintenance department, and all of those things, those are all located outside of the county of Madison.
Mr. Chairman?
Senator Spruill.
So now, you got two that have the authority to operate on its own. So then you got one, if this happens, so you got one county, which is Madison, they don't have the capacity, the facility, and what have you, to run its own. Then what happens to Madison County? Can someone answer that question? If that happens, you got two say, hey, I can operate by myself. Madison County needs our help. Now they're out there by themselves. They don't have the capacity to do what they want to do. Then what happens to Madison County?
Mr. Chairman?
Greg? Somebody?
Sure, I'd be happy to answer the question because Senator Spruill's hit the point. The whole point is you can't just withdraw. That's not what this bill does. It requires a negotiated withdrawal and a distribution of assets. Madison will have more leverage in that negotiation than it's ever had on any issue in its entire history. Madison can force the parties to negotiate a withdrawal that is consistent with Madison's interests. This does not cause the RSA to dissolve. There's a separate dissolution statute. This simply allows a negotiated withdrawal of one of the parties, getting to Senator Spruill's question.
All right.
Thank you,
Mr. Chairman.
Who's that?
Hey, it's Rob Shin again.
Yeah, go ahead, Rob.
So just to give the alternative point of view, I totally disagree with that. I mean, the reason why the current statute requires all 3 localities to sign off is to protect the most vulnerable, the Madison counties of the world. The fact is, if this bill passes, Madison is very exposed. What's going to really solve the issues is a thoughtful, deliberative mediation process where the parties get together and sort it all out. And Green very well might be able to leave, but on terms that are acceptable to Madison, so their customers aren't left without water service.
All right, we've spent a lot of time on this. Let me say a couple things and wrap up. I think Senator Hanger, in his inimitable way, has accomplished his objective by bringing everybody to the table. We've got, at one time it sounded like 3 pieces of litigation, then there was a consolidation, so maybe now we just have 2. It has been the custom of the legislature not to do anything that may trespass on the ongoing litigation. Mr. Habib raises the question that it does not directly impact the litigation. I don't think we can decide that here. It sounds like it comes awfully close to impacting the litigation to me. What I would say to all 3 parties is, you sound like you're at the table. You have an excellent mediator who has brought peace in the valley many times here for many more contentious issues than this in the city of or in the capital here. So I would urge you to make use of that excellent resource, because I will say this, no matter, I don't know what's going to happen to this bill, but we come back here every January, and some of us come back here repeated Januaries, and some of us serve on this committee, and we'll be back here in January. And so I would urge all parties in good faith to try and reach some resolution, regardless of what happens to this bill here this morning. So, anybody else?
Mr. Chairman.
Senator McPike.
I guess one sort of issue on lines 32 through 37 in terms of the State Corporation Commission, the framework really limits the SEC's review to what is contained within this bill. And to Madison County's point, the issue does not say and best interest of the Commonwealth or best interest or other sort of safety provisions that normally the SEC would be given authority to review. Otherwise, I think the rest of the bill has a fairly strong framework of helping the motivation. So I would just note that because that section, specifically line 32 through 33, does not have sort of what we normally do with State Corporation Commission is that allow them and actually review. This solely confines them to the letter of what's written within this bill. And I would say that is my red flag. The rest of the bill I don't have a problem with. I don't think it interferes, and I do think it provides a motivation, but there's not a safety, there's not a relief valve in here for the State Corporation Commission to do their job. And Mr. Chairman, if either
Mr. Chairman, can I address that point?
Greg Habib has a comment, I'd happily entertain that.
Go ahead, Greg.
Mr. Chairman, that's existing law. So if you look at 5112, the SEC's role is if the state corporation confines the application conforms to law, it shall approve the application. They actually don't play an analytical role in this process. They simply receive the application for withdrawal, confirm it meets the code, and then allow withdrawal. So I understand the desire to expand SEC scope. This is not where they have authority.
All right, we've been going on a long time. It's 10:11.
Mr. Chairman.
Senator Favola.
I'm sort of inclined to let things play out because it's unclear to me if this will help or hurt the current mediation framework, which is already in place. I guess they've hired a mediator, as you just mentioned, and we do have 2 court cases. So I have the greatest respect for the patron, and I want to help the patron as much as I can, but I don't see a pathway forward for this bill. If you wish to defer the bill and carry it over for a week, I'd be, I'll go along, but I don't see a pathway forward. Am I missing something?
I don't think that works calendar-wise, Senator Favola.
I didn't think it worked either.
Mr. Chairman,
Do you want me to make a motion?
I'm ready for a motion, Mr. Chairman, myself.
Senator Sproul sounds like he's full of fire, so
Yes,
let him
sir.
go ahead.
I move as the minute be reported.
Second.
All right, it's been moved and seconded that the bill be reported.
I don't know what to do.
You did what you needed to do. All right, the bill fails to report.
Thank you, Madam Chair. Mr. Chair, just one comment in parting. This was not a personal thing for me, and actually, the members are correct, at least in part, Mr. Chairman, you are as well. The bill caused a negotiated settlement to start last week. We have Mark Rubin at the table, and I just want to encourage all the members of that service authority to address this issue rather than going to court. I know we had a number of attorneys wanting it to go to court, but that's their thing. But I would rather it be resolved in the favor of the people they serve. Thank you.
All right, thank you, Senator Hanger. I believe that completes our docket for today. All right.
Thank you for the committee's time.
Yep, thank you. We are adjourned.